Hello everyone, welcome. This is Kshama Pandey and today we will be talking about Article 20 of the Constitution of India. Article 20 of the Constitution of India is our fundamental right, and this fundamental right is important in the sense that this right gives three most important rights to an accused person, that is ex post facto laws, double jeopardy and self incrimination. So, Article 20 has three clauses, clause 1, clause 2, clause 3. All the three clauses have different concept, okay? And they all are for accused person. So, let's see one by one what are these three concepts, and we will start with Article 20, clause 1, which is ex post facto laws. Now, firstly, you have to understand that what is this ex post facto laws? So, it means that the laws which punishes those acts which were lawful when it was done. For example, there is a person A and he has committed something in the year 2020. Any act he has committed in the year 2020. Now, the Parliament of India has legislated a law and it was passed in the year 2024. Now, this law, which has been legislated by the Parliament, makes this particular act which A has committed in the year 2020 when there was no such law. This law of 2024 is actually making this act of A which A has committed in the year 2020 as illegal or unlawful. Now, in this case, this A has immunity under Article 20, Clause 1 of the Constitution of India, that is ex post facto law. The thing is, a person cannot be punished for the act which was lawful at the time of the commission of that particular act. And there is one more concept in the same article, that is, a person cannot be given a greater punishment. A person cannot be given a greater punishment than what is mentioned in the statute at the time of commission of a particular act or offense. So the thing is, a law cannot have retrospective effect and can make a particular act an offense. So this kind of law which make a particular act an offense is only possible when they are for future. They cannot go back in time and make some act as offense. It is only for future. So this is the gist of Article 20, Clause 1. For example, if you remember that in IPC we have section 3041, clause 1, 304 clause 1, which is related to dowry death. Now this clause was inserted in IPC on 19th November and 1989. If I am not wrong, let me check the date, 1986. 1986. Now, in the year 1986, Parliament inserted this clause, that is section 301 clause 1 in IPC and made dowry debt as a punishable offense. Now, it is not like that all the dowry debt that was before 1986 will be punishable. So, all the cases in which there was dowry death, so it is not like all the relatives will be asked to come into the court and they will be punished. No, retrospective effect cannot be there. It will be from this date onwards. All the dowry deaths will be punishable under section 304 clause 1 of IPC. Understanding? So a law cannot punishes a act which has been done at the time when such act was not offense, when that act was not punishable. So a law cannot go back in that time and punishes some act which was committed at that time when it was lawful. Such kind of law can only for future. Now there is one technicality in this clause, that is this article is only for criminal liability. This is not for civil liability. The word which is mentioned in Article 20 Clause 1 is only offense. Okay, civil liability is not a part of Article 20 Clause 1. So, if the parliament is making some laws which is related to tax, that is, if imposing some kind of fine and it's a civil liability, then that is not under the ambit of Article 20 Clause 1, and we have Supreme Court case laws on such kind of issue. Okay? So Article 21 only covers criminal liability, and this is not applicable for civil liability. One thing also you have to keep in mind that Article 20 Clause 1 is not applied on departmental proceeding or disciplinary proceeding. So this is only for judicial proceeding. If some person has been, has been given some kind of punishment in department as an outcome of departmental proceeding, that is not covered by Article 20 Clause 1. Now, another or the later part of Article 20 Clause 1 is that no person, no accused person shall be subject to a greater penalty than what was mentioned in the Act at the time of the commission of offense. Okay? So it is not like that in the year 2024 when A has committed some offense and the penalty was maybe 5,000 rupees. And in the year 2030, the Parliament of India amended the Act and has increased the penalty up to 10,000 rupees. So it is not like that if the court is passing the judgment in the year 2032, so the court has to take into consideration the amount of punishment which was mentioned in the Act at the time of the commission of the offense and not which was added later by the Parliament of India. So greater penalty cannot be imposed. This is the case. And on this point only we have a case law which is Kedarnath versus State of West Bengal. Now what happened in this case? Kedarnath has committed an offense in the year 1947. In the year 1947, Kedarnath has committed an offense, and that offense was subject to penalty as well as imprisonment or both, either penalty or imprisonment or both. Now, what happened? Later, the parliament for the same offense increased the penalty amount. So, what the court is saying, the Supreme Court is saying that the enhanced punishment prescribed in the Act, which is later added by the Parliament, is not applicable for the offense which this Kedarnath has committed in the year 1947. तो तुम अगर बाद में अगर पार्लियामेंट बाद में कुछ मॉडिफाई कर देती है, अमेंड कर देती है, then the accused person which committed a particular act in a particular year, and in that year that particular penalty was not there, will not be subject to such penalty which is later amended and added by the parliament. हिंदी में बोले तो अगर एक व्यक्ति एक ऑफेंस करता है एक पर्टिकुलर दिन में, ठीक है, एक पर्टिकुलर टाइम पे, फॉर एग्जाम्पल आज मैंने कोई ऑफेंस किया, दैट इज इन नवंबर 2025 आई हैव कमिटेड एन ऑफेंस, और उस ऑफेंस का जो पेनाल्टी है मे बी दैट इज 5,000 रुपीज और इम्प्रिजनमेंट है मैक्सिमम 6 मंथ. ठीक है, ये मेरा ऑफेंस की पनिशमेंट है जो मैंने कमिट किया. अब क्या हुआ, पार्लियामेंट ने 2026 में इसी पनिशमेंट को अमेंड करके पनिशमेंट बढ़ा दी. और बढ़ाई कैसे? अब मैक्सिमम 6 मंथ की जगह अब मुझे मिनिमम 6 मंथ मिलना ही है, एंड मैक्सिमम इट कैन गो टू 10 ईयर्स. और फाइन इसने बढ़ा के, पार्लियामेंट ने बढ़ा के कर दिए 50,000 रुपए. ठीक है, इस सिचुएशन में मेरा केस जब भी डिसाइड होता है सुप्रीम कोर्ट के द्वारा, maybe in the year 2026, 2030, 2050, in whatever year, my punishment will be according to that law which was in force at the time of the commission of the offense, not according to that law or according to that provision which has been later amended and modified by the Parliament of India. So this is Article 20 Clause 1, and on this point we have